Good afternoon. Uh, we are going to commence this hearing starting today at about 1 o'clock. The items that the public hearing referred to are, and I'll just read through them for those who may not know, at least as it relates to the first person testifying, which is the claims commissioner, are the resolutions before us. Senate Joint 40, 41, 42, 43, 50, House Joint 51, 52, 53, 54. Mr. Claims Commissioner, how are you?
Good afternoon. Good afternoon, Senator. Thanks for having us. I'd just like to briefly introduce our team.
Please
The
do.
Claims Commissioner's Office. This is 4/5 of our team, our very hardworking team. Tara DuPont to my right is paralegal specialist. And then we have Janae Carter, who's a paralegal specialist, and Brinna Ledwood, who is a paralegal intern from Manchester Community College. By the way, our community colleges have a fantastic paralegal program. And if any lawyers are listening, I recommend they reaching out to Manchester to talk about getting help from paralegals. So we're grateful for the opportunity to help the Judiciary Committee analyze these awards that we've issued. And we'll do our best to answer any questions you have. And it might be that there might be a question that I can ask Tara or Janae to help us look up the answer. These claims are very complicated, as you folks know, and there's a lot of documents and a lot of information. And I just want to again say that these folks sitting to my right are the hardest working people in state service, and the citizens should be grateful for their work. They do a really great job. Thank you.
Thank you. And I think we say it every time you come here, but we are grateful to the work of you and your office for getting us back on track. So with that, are there comments or questions from members of the committee? Representative Fazzino.
Thank you, Mr. Chair, and thanks for joining us this afternoon, Commissioner. And we, again, appreciate all the work that you and your office have done to timely settle these claims. This is more of a general question about the process for folks at home, but we were talking a little bit before this meeting about how these claims are calculated, and we were just wondering what are the factors that your office considers when they're deciding on a claim award, and what facts they look to, what calculations go into the final figures that are in front of us today.
That's a great question. So last year in 2024, this committee in the legislature passed Public Act 24-106, which sort of very carefully lays out the calculations and the factors that go into the decision for an award. So under that new law, which, we tested a little bit during this summer and in fall with 3 claims that went to a full-blown hearing. Under the new law, the first step is to determine whether or not a person is eligible for compensation. And that's laid out at the beginning of the law. And then if the person is eligible for compensation, there's an analysis done where you start with the fact that for every year of wrongful incarceration for a person, that the person would get about 200% of the median household income. Let me make sure I'm using the right term. Median family income. So, for example, in 2018, the median family income in Connecticut was $96,300. So the person would be entitled to 200% of that. And then the statute also allows the Claims Commissioner's Office to increase that award per year, or increase the total award by 25%, or decrease it by 25%. And there's factors that go into that decision. So for the 3 claims where we had hearings, we actually took evidence on all those factors. We took evidence on the calculation of the median family income, and the Claims Commissioner's Office made a decision to move the awards upwards by 10 to 15% based on the testimony that was provided by the claimants, their families, the effect of their long periods of wrongful incarceration on their families and on themselves. So I think, and I think the parties involved would agree that the statute works very well and works very fairly, the statute that this committee passed last year. So that's the process, and it seems to work very well. I haven't heard any complaints from any of the parties.
It seems like it strikes a pretty fair balance between having a set rubric so that these awards don't just come out of left field, right, on the one hand, but also with this 25% adjustment, allowing some discretion to look at the individual facts of a wrongful incarceration and make adjustments accordingly. So would you say that that's sort of how it's played out in practice as well?
So far,
Okay.
we had 3 hearings, and that is how it played out.
Okay. Thank you for that context. We
Oh.
appreciate it.
My pleasure.
Thank you, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Commissioner and your staff. Commissioner, I want to focus on eligibility because you sort of like, you didn't have a lot to say. I think we need to go through these files one by one. The first one on our agenda is the Carmen case. And, you know, generally that case had to do with ballistics evidence, and there was 2 eyewitnesses that I believe recanted, right? That's, and the ballistics were faulty. Is that fair to say?
Yeah, let me start by saying this, Representative Fishbein. We did not have a hearing on the Carmen case. That was resolved through mediation by the parties.
Understood, but at the end of the day, you're the one here presenting the results of the work and asking us to approve. So are you saying that you had no part in determining eligibility here, that was agreed to by the AG's office without your office's involvement?
So yeah, that's how it worked on 5 of these claims, and I'm happy to go through it. When I hear from the parties, and all of these gentlemen were represented by skilled attorneys, when I hear from them about a proposed settlement, or when our office, I shouldn't say when our office hears about a proposed settlement, we review the documents that we have in the claim file. We analyze the allegations made by the claimant as to his or her eligibility. And we then look and see if the proposed amount seems to be fair based upon the amount of time the person was wrongfully incarcerated. And then I had informed the parties that this seems like a reasonable settlement and one that the Claims Commissioner's office could support.
And I just want to focus on eligibility. So does your office get involved in reviewing the file and determining whether or not the person is eligible under the statute? Because certainly you don't get to a number until you determine eligibility, right? So you part of that process also?
I was in 3 claims. We were part of that process in 3 claims, in the Jackson claim, the Horn claim, and the Morant claim, but not in the other 5 awards before you. I guess I will admit that I trusted the parties and the attorneys representing the parties, that there was a determination made that they believed that the claimant was eligible. Now, I will say in one of these claims, the Glass claim, which is the 8th claim on your agenda, that for the amount of time that the person was incarcerated, the award is actually a low amount, $120,000. So I received information from the parties that there may have been a dispute about eligibility if it went to a full hearing, so that they decided to resolve the claim at that amount of $120,000.
Okay, so I starting one by one, looking at the Carmen claim, are you sitting here in support of eligibility on this claim?
Yes,
Okay. So when we look at the statute, and the statute is 54 102 UU, so W. In order to find eligibility, it says you have to find that the conviction was vacated or reversed. Okay, so we've met that one, right? Correct?
yes,
Okay. And then we have to determine that it was dismissed on the grounds of innocence or grounds of consistent with innocence or some action by a state actor that constitutes malfeasance. You would agree with me?
yes.
Okay, so those are the two buckets, right? So in the Carmen case, what grounds consistent with innocence were determined, or what is the basis of your position on eligibility?
I honestly, Representative Fishbein, I accepted the resolution from the parties on that matter. We did not make a finding, we did not make a formal finding on eligibility. We accepted the proposed settlement agreement.
Okay, so I'm having trouble, it's all too often easy to write the check when it's not coming out of your account. But in the Carmen case, there was Judge Alander wrote a very lengthy decision. And on page 48 and thereabouts, he expressly says, there are no findings of innocence here. There was bad procedure. So either someone in power is rejecting that judicial determination or they're shifting to malfeasance. But Judge Alander didn't find malfeasance either. So how can I find eligibility in this case? I was certainly in support of the bill that we passed last year, but I didn't want, I think anytime anybody's life and liberty is taken away improperly, they should be compensated. But I certainly didn't want a process where checks are just being written for, I think in this case, it's like $4 million without
Actually, 7.9 billion, of
statute.
course.
What?
Carmen is a larger award, I believe.
Yeah.
He spent 29 years incarcerated. Yeah, so my understanding of what was presented to us was that the state nollied the charges based upon Mr. Carmen's constitutional right to a fair trial.
Yeah, and the basis of the nollie was he had spent 29 years in prison and all the witnesses are dead. And the evidence isn't there. So once again, Judge Alander didn't say it's innocence. They talked about the length of time. So I guess with regard to Carmen, it's a big old question mark as far as eligibility. I don't have a problem with the calculation, right? Once you get there. But I think we have a duty as legislators to make sure that the statute's being followed. And I don't know how we get through eligibility given the file. The next one is Morant.
Well, what we could do, Representative Fishbein, if I know there's a deadline for deciding these, but I can follow up with the parties immediately and make sure that get information to the committee about eligibility. I don't want to make a determination from the claims commissioner's office about eligibility where we did not have a hearing on that question. So I think it would be maybe difficult for us to do that.
Yeah, I mean, I would want to hear from the AG's office. Basically they punted on eligibility. is what I'm seeing here. And they just said, okay, he's eligible, Mr. Claims Commissioner, do the calculation to make sure the number that we've agreed to write of the taxpayer's checkbook makes some sense, right? That's what happened here.
Yeah, so
Right.
I'll talk with the folks from the Attorney General's office and ask them either through our office or directly to follow up with you for sure.
Okay, thank you.
But,
On the
but I will say the way I've handled in these 5 of them, the way that our office has handled them, that, you know, we're happy to hear from parties when they've informally resolved a claim. But I hear you loud and clear going forward, and we have 7 other pending claims for wrongful incarceration. I will make sure that's part of our office's analysis. Like, please tell me precisely, I'm guess whether, I don't know if this is appropriate, but please tell me how you've come to an agreement on eligibility. I mean, I can certainly ask that going forward.
Yeah, I mean, it would have been helpful if somebody from the, I know they were just there this morning. If somebody from the AG's office was hanging out and could answer that question, because I just don't see it from the file. I see the opposite. So, you know, once again, if they meet the statute, they're eligible, the check gets written. On the Morant case, obviously Detective Rauchi was a bad actor. And you know, I can see the malfeasance in that case, and that case you heard in your office, correct?
That's true. We had a full
Okay.
hearing, yes.
So that was a $5.1 million award calculation before your adjustment. And you increased that by 12.5%. You added $646,000 to that. And I know Representative Fazzino was touched on this in the beginning, but how did you come to 12.5% increase?
That was actually, after the hearing, I informed the parties that the Claims Commission's office was going to find eligibility and that the formula would be applied. I also told the attorneys for the parties that the Claims Commission's office would be making an award upwards of that amount. And the parties agreed to the 12.5%.
All right, so so post-hearing, you
Based upon the evidence that was presented at the hearing, Rep. Fishbein, I think the parties heard the evidence and they ultimately agreed to the upwards award of 12.5%, which seemed reasonable to me, to us.
Yeah, I'm just trying to get through because you know, you're sitting as judge and jury and making the determination based upon the facts that you hear. You know, I've never heard the trial judge contacting the parties and saying, this is what I'm thinking about awarding, and then them coming and taking that representation and negotiating and coming back with some sort of settlement agreement. That just seems unusual to me.
It might be, but to be honest with you, that's what I did.
Okay, so what portion of the statute allows for that? I thought it's just in your discretion, you can award. It's not stepping into negotiations. You know, it's almost like the jury, you know, knock, knock, knock. We're thinking of awarding 4 million, and the parties go out in the hallway and they say, well, we'll settle on 3. The jury hasn't done their job. So what, is there a portion of the statute that allows for that interlocutory negotiation with the trier of fact?
I don't believe so. But, and I hear you loud and clear in this. You know, I was looking at this as if we can resolve claims by agreement of the parties, that is something that the Claims Commission's office would certainly support.
But it's wholly within your discretion as the commissioner whether to give anything in addition, right?
I think I think I'm correct in recalling that I did suggest to the attorneys that I was gonna award more. And if they could agree on a number, that I would look at that. And I looked at it and I agreed that the number of, I believe it was 12.5% was reasonable in the circumstances.
And what's the max that you could?
25.
Now, in the Horn case, which is the third one on our docket, Horn and Jackson are inexplicably intertwined.
Yes.
They were co-defendants. Generally in this case, this was a technological advancement case, right? Exoneration would not have happened unless technology had improved with regard to cell phone determinations. Is that fair?
Yes.
And were you part of determining eligibility on the Horn matter?
Yes.
Okay. And which portion of the statute did you rely upon in determining eligibility?
On the very first section, which requires under 54-102 UU subsection A2 that the conviction was vacated or reversed on grounds of innocence or grounds consistent with innocence. And I think we may have written that in our written decision.
So you found that if at the time of the conviction, the cell phone calls had been traced back to Bridgeport as opposed to New Haven, that no proper jury would have convicted Horn and Jackson. Is that fair?
I don't know if I looked at it that way. I think we took testimony on how the conviction was vacated or reversed.
Well, it was vacated or reversed because originally at the time of conviction, a cell phone was stolen. It was alleged based upon the records of the mobile company in existence at that time that those cell phone calls originated from New Haven. The perpetrator or the accused were in New Haven and therefore convicted, I think, solely on that. In fact, I underlined there was no physical evidence in this case at all. There was only the cell phone calls that were attributed to whomever committed the murders. Now, fast forward over a decade later, conviction was 2019, 2018. They determined that those calls came from Bridgeport instead of New Haven, and there was no way that they could have been in Bridgeport at the time. Those are basically the reason why it was vacated. So, my analysis was, if we knew then what we know now, would there have been a conviction? Is that fair?
That's fair.
Okay. And I would think that going forward, that is what is used to determine eligibility on the first prong. That makes the most sense. It does run contrary to Carmen, because Judge Alander's very lengthy decision in that case. But I think it does apply here, and I think that was the legislature's intent to expand, right? It's not just exoneration and finding of innocence, but it's grounds consistent with innocence is what the statute says. All right, so number 4 is Gould. And Gould was a stip also. In Gould, once again, no physical evidence. Gould spent 26 years incarcerated. Stiles, she was, I believe, addicted to drugs. She claimed that under very lengthy interrogation, she claimed that she witnessed the murder. She did years later recant. However, she recanted for the habeas trial 1, the Supreme Court overturns that habeas trial. There's habeas trial 2, at which Stiles invokes her Fifth Amendment right against self-incrimination. So the question there is, once again, the eligibility issue. The Supreme Court never found that Stiles was telling the truth when she recanted. In fact, I think that was one of the reasons for them overturning that habeas trial. And you had no part in determining eligibility in the Gould case, right?
That's true.
So in the Gould case, the state attorney moves to vacate and return it to the docket. In 2024, it's granted, and once again, the state's attorney enters a nollie. So very similar to Carmen. So I would like to know, once again, from the Attorney General's office, no malfeasance at all in this case, right? No physical evidence. There's no claim of, any Brady violations, nothing like that. Why, if anything, it might be ineffective assistance of counsel, which I got an issue when the state is then compensating somebody if it's ineffective assistance. I don't, and certainly ineffective assistance is not in the statute, right? So it's got to be grounds consistent with evidence, with innocence, or malfeasance. And I don't see the eligibility in the Gould case. So I'd like to know more about that. Number 5 is Jackson, which I think from my perspective is okay. It's tied to Horn. He was the co-defendant. Moving to LaPointe, which is number 6. And not your fault, Mr. Commissioner, but LaPointe is an example of justice denied is justice, or justice delayed is justice denied. Mr. LaPointe served 25 years and 9 months. His claim was filed in 2016. He died in 2020. It isn't until 2025 that we're dealing with his claim. It's as a result of those many claims that weren't dealt with during that period of time over the last decade or so. I think I have to commend attorneys Keenan, Cousins, and Castellero. They're very well written brief. I was blown away by how well that was. In this case, there was a Brady violation. So, and it's judicially found. So I guess that's the malfeasance, and DNA ruled him out. So I think I was okay with eligibility, and once again leave the calculation. Number 7 is Dawson. Another stipulation. Did you have any part, Mr. Commissioner, in determining eligibility on the Dawson case?
I did not.
Okay, I'd like to know once again why they found eligibility, and just want to, go over the facts a little bit here. This was a constructive possession of a firearm case, and a gun is found in a bush near the defendant. DNA is taken from the gun, and it's his DNA along with other individuals. The state argues that he must have been in some proximity to the firearm in order for the DNA get on that. He's convicted. Now, when the case gets to the Supreme Court, they deal with transfer evidence of DNA, and that there was not proper cross-examination as to how the DNA could have gotten there. But I question the eligibility once again, because when we read the Supreme Court opinion, Justice Robinson, his dissent is all about innocence and overturning what a jury found and things like that. So once again, it's not malfeasance. There's no allegation in the Dawson case of any state actor doing anything wrong. We have to go to the other side, which is presumption of innocence or facts that lead to innocence. But that wasn't what was found by the Supreme Court. So once again, I'm hung up on eligibility. And Glass being the last of these, reviewing my notes. It has to do with DNA and transfer once again. The appellate court vacated and ordered an acquittal. And this is the one that I get, when I reviewed the file, under the calculation, because he was in for 6 years, he would have gotten $936,000. But he agreed to $120,000, and eligibility was questionable in that case. So how do we get there when? So the AG's office stipulated to eligibility and writes a check or proposes to write a check for 1/5 of what the gentleman's looking for. Is that in resolution of the case in its entirety? Is that what I'm to understand is before us?
Yes, sir.
And
So-
did you have any part in that?
I did not. So this is a really important and interesting discussion. I'm wondering if the Claims Commissioner's office going forward said, before we can agree to award, we have to hear from you precisely how you determined that the claimant was eligible. And I'm wondering if that might put the parties in a difficult position. I guess this Glass case is a claim is a good example, because the parties have agreed not to litigate eligibility. They've agreed to informally resolve the claim. So I'd like to have further discussion with this committee and with other interested parties about how much our office should appropriately insert ourselves into that finding. But I do hear you loud and clear. It's an important issue. So
Yeah, I mean, the problem, and maybe we created the problem by passing the statute that we did, right? Because
all right,
originally
I'll take that as an answer. Yeah.
I mean, originally it said you had to be found innocent, which, was sold to us that that's too difficult of a bar of a hurdle to deal with. But on the other hand, I didn't want, I'm going to call up the AG's office next week and say, hey, send me a check for $100,000. And they say, well, your claim was $1 million and we'll send you 100, even though, we have no liability. That's
I will say this, if I could, Representative, in my tenure here, which is about a year and a half or so, the AG's office fights very hard to defend the state of Connecticut. I've not seen them yet sort of give up on a claim that should be defended. So between the AG's office and the parties, oh, by the way, if any of these parties were not represented by counsel, I certainly, the Claims Commissioner's Office would certainly be digging into a resolution much more deeply. But in every one of these claims, they're very experienced in hardworking assistant AGs representing the state and very experienced, hardworking attorneys representing the claimant. So I admittedly did rely on them for their determinations as to resolving these claims. And I do want to talk with folks how much the Claims Commissioner's Office should insert itself into those discussions on eligibility. I don't know. It's an important point.
And I appreciate all that. I just, I have a duty to the taxpayers here, and as I said, if their life and liberty is taken and it was wrongfully taken, I don't have a problem with compensation, but if we're going to ignore the eligibility portion of the statute, and I'm not accusing anybody, but I don't see it in the files. You got judges saying this is not innocence and this is not a presumption of innocence, and yet somebody's making that determination. I'd like to know why and how, because maybe the statute needs to be reined in, quite frankly.
Well, maybe a suggestion is that to take our office off the hot seat a little bit, which we would like, is you could, and you'd have to talk with the parties, but you could amend the statute to say that when there's any proposed resolution, the parties must state how it is they came to potential eligibility. Then I don't know if that's appropriate in a formal resolution. I don't know if that would happen in civil court. Like you're settling a case, but you have to explain why there was a finding that the defendant was negligent. It's an important issue. We have to kick it around.
Well, many times you send an interrogatory to the jury to determine a particular portion of the case, right?
There's no jury yet, though. It's an informal resolution before a hearing.
Understood, but it's a process that we have statutorily created to, absent this process, somebody could sue the state, right? They go before a jury, they plead their case, and there could be interrogatories to the jury. So we have chosen to expedite that process by statute, and this supplants that right to a jury, hopefully smoother. But there's another item on our agenda. I think it's a award of $50,000.
Oh, yeah.
Can you, I think I got the backup really, really late for that.
I think maybe
have not-
that might be a claim that you might be having a hearing on. I don't know whether that was just raised for a public hearing. That's the Robillard claim.
Okay.
That's something that is not often done, according to my colleague Tara, who's been working for our office for some time, where the Claims Commissioner's Office is allowed to recommend a settlement to the General Assembly. And because the Claims Commissioner's Office can only award up to $35,000, or we can grant permission to sue. A third thing we can do is recommend a settlement to the General Assembly. So this is frankly kind of a test case. I understand that, we communicated with the parties and they have agreed that a $50,000 resolution of this claim is appropriate. So we respectfully recommended this claim for review to the General Assembly.
Okay, on our agenda, and this is it's under Roman 4, item 9. It says resolution authorizing the Claims Commissioner's recommended payment of $50,000 to the claimant Heather Robillard. So I don't read that as raising something that we're going to have a public hearing on. I'm going to defer to the chair as to procedurally if I'm going to get another opportunity on that. Otherwise, I'd like to hear more about that if we're going to vote on that today.
Yeah, I don't know if it's on the. Oh yeah, I'll defer to the committee on that. But it's similar to down the road here. This session, we're going to have public hearing on 35 of the claims that the Claims Commissioner's Office either denied or dismissed. Those folks asked our office for an appeal. So I thought that Robillard would be part of that proceeding, and I apologize if I'm wrong.
Okay, that would be in line with what you said before, that when we do claims on that particular day, we'll be raising or we'll be dealing with Robillard, and everybody will get their chance to tell us why we should or shouldn't do certain things. Okay. All right, with that, Mr. Chairman, I'm going to defer. So thank you for everybody's indulgence.
Thank you, Representative Odette.
Thank you, Mr. Chair. Just briefly, and I appreciate the good ranking member's thoroughness on these claims. And in talking to the AG's office, I think what might make sense is having the state's attorney's office do this kind of gatekeeper role rather than the attorney general's office. But I'm happy to work with the good chairs and ranking on seeing if that makes sense. I don't know if you, sir, have any opinion on that, kind of moving it away from the AG's office and putting it to the state's attorney's office. Would you have any problem with that?
Hi, Rep. O'Day. As far as making a determination
on eligibility. Yes.
Yeah, again, you heard my concern about whether or not the parties are prepared to say that someone was eligible as part of a resolution. There might be a dispute. You know?
Right.
I think that has to be the caveat on this.
All right.
And again, you know, another option, we love doing hearings at our office, right? I mean, we have hearings all the time. So if you want us to have full-blown hearings on these claims, we're happy to do that. I don't, that's the legislature's call.
All right.
And then the Claims Commissioner's office would be officially making a determination of eligibility, which now that I'm saying it out loud, I don't love that idea, but that's because people should be allowed to resolve their claims without, you know, and again, these claims are really hard. They're all gentlemen this year. The three of them that we did hearings for, they came to the Claims Commissioner's office and they brought their family members, and it's really hard on everyone, really hard. And so to the extent that these things can be resolved informally, in the Attorney General's office, they work very hard representing the state. I think if we can get these, if there's a way that we have to change the statute to have these resolved informally, if possible, I think that's good. And 5 of them were resolved informally. And I think that's a good thing.
All right. Thank you very much. Thank you, Mr. Chair. Senator Kissel.
Thank you very much, Chairman Winfield. Commissioner Shea, it's always great to see you and appreciate all the information you've given us this afternoon, as well as reaching out to my office and myself earlier on to go over some of these matters. But I don't want to take a lot of time, but you have 3 wonderful individuals that came to join you, and they've just been so patient and sitting there. And I want to afford them this opportunity to just offer any insights, or so if each one of you could and start on to my left. So this young lady there, if you could just state your name for the record and give me some incisive insight regarding any of these matters. Is there any one particular case that you felt was particularly heart-wrenching? Just anything that you can tell us that might help us.
Oh, well, excuse me. My name is Brenda Ledwidge. I'm the paralegal intern. I only started with the office 6 weeks ago, so I've not had the opportunity to work on these cases, but I know that Janae and Tara have had the ability to.
That's good enough. That'll work. All right, next, please.
Hi, I'm Janae Carter, paralegal specialist. I started here in October. I did have the opportunity of hearing the Stefan Morant case. It was pretty much 7.5, 8 hours of a wrongful incarceration hearing. It was very tough to hear the testimony of their families and everyone involved. So that's my input.
Can I just ask one follow-up on what you said? Why is it just that because you're a human being and you've got a heart and you just say, God, but for the grace of God, I could be wrongfully incarcerated? Not you personally, but like any human being on this planet. Or was there something else that caused you to feel that it was really difficult to hear the testimony?
It was difficult because I just heard the testimony, like he lost several people during his incarceration. It's difficult for him to connect in society now because he's been incarcerated for so long. So that's just difficult for me. He was raising children also that he had to connect with while he was incarcerated. I have young boys also, so that to me is challenging to hear what they went through during his incarceration.
Thank you. And you may not think a lot of, but like, we're here as fact finders and trying to glean as much information we can in a really narrow period of time. And so what you're doing is I have something that's essentially, by way of analogy, black and white, and you're adding color to it. And so I appreciate that, because it wouldn't be the first thing that would pop into my head. I'm thinking about a person wrongfully incarcerated. Did they meet that threshold? How many years? What's sort of the calculus? And what you're saying is that, yeah, that's a portion of it. That's a critical portion. It's almost mathematical. But what happens when a person is taken out of the life lane and put in the incarceration lane inappropriately, unjustly? What does that really mean? And it means they're missing out on so many things. It's just like if someone was sent overseas and they missed the birth of a child. But this is even worse because this is an injustice. And so, and yourself, the third young lady?
Hi, my name is Tara DuPont. I'm a paralegal specialist. I've been with the Claims Commissioner since 2012. So I've seen all the wrongful incarcerations from Ireland all the way up to now, in one way, shape, or another.
And just if you could offer, that's 13 years now. So
Yeah.
if you could offer like maybe one pithy insight that could be helpful. And how do
Um,
you like working with our new commissioner?
I love it. He's fantastic.
Paid her to say that.
It's my third one, so he's doing
All right.
great.
There you go. That was your Valentine's present there, Commissioner Shea.
I mean, some of them are easier than others. The one that sticks out the most to me is the LaPointe case, just because he passed away prior to a decision actually being made. And that's hard to handle, just being a part of the office for so long. It kind of just sticks with you.
Yeah, I really appreciate that. In my neck of the woods, North Central Connecticut, one of the papers, it's still around, but I don't want to kick it, but it's not the same as it was once upon a time. And that's the Journal Enquirer out of Manchester. But there were an awful lot of folks in the media when I thought that they did a lot more local reporting that were championing that cause and the fact that it seems so incredibly unjust. And, it's unfortunate that he has since passed and it's taken such a long period of time. But it's good to eventually resolve things in a positive, just way. So appreciate the positive shout out for your commissioner there that you're working with, and I'm blown away, Commissioner Shea. I'm just, I appreciate our ranking members digging down deep and getting to the roots of these matters. But above and beyond that, we had, and I'm not blaming anybody, past commissioners took different approaches. Some of them may have taken on more than was necessary in trying to create decisions that may have been best left for a Superior Court judge. But that being said, we're here now and the matters are moving so much more efficiently. I don't think that we're losing anything in the process. And as my friend and colleague, Chairman Winfield said, when the good ranking member said it as well, justice delayed is justice denied. And that's first and foremost. Nobody wants to be treading water. Time we cannot get back. And so you are just moving the business, and I feel in a really good way. So kudos, commendations, but I just wanted to put that on the record this afternoon. Don't speak. Don't speak. You don't have to speak. End on a high note. It's always good.
I'd like to just say one thing. Yeah,
All right. But if you dig yourself a hole, don't blame me.
the credit goes to all these people sitting to my right. I mean, in any law organization, the paralegals do all the work and the lawyers just make a lot of noise. But they work really hard. Our claims keep coming in and they're very dedicated to being as fair as possible to all of our claimants. By the way, 59% of our claimants are pro se. So we have to work very hard to make sure that we're treating people fairly. And that's our primary goal. And these women are just awesome. I mean, all I really have to do is show up at the Judiciary Committee, get beaten up twice a year. So, I mean.
Nah, we're not beating
it's-
you up. Well, since we're doing a love fest, very appropriate for Valentine's Day, I'm going to give a
Yes,
shout
very
out to
appropriate.
Elise and Evelyn in my other capacity. They'll know who they are if they're watching this on CTN, and we'll leave it at that. Thank you, ladies, for coming in to testifying this afternoon. Thank you, Mr. Chair.
Thank you, Senator Kissel. Comment or question from others. I guess I'll just take my turn first and then I'll call on Representative Staffstrom. A question about related to these claims. I've had, and I think you know this, Mr. Commissioner, I've had opportunity to engage with some folks who have had claims before the state for wrongful conviction, and I've become aware of organizations that loan to them and the makeup of those loans that seems almost, if not usury. Can you make some comment on that? I think it's an important thing for the committee to be aware of, and perhaps try to figure out what we can do about these folks who think they're going to get an award, but significant portions of that award are taken because of agreements they've made in order to survive.
Yeah, thank you, Senator. A very important question. We had one claimant in particular. I don't know if he'd appreciate me saying his name, but there's one claim where we had a hearing.
Just I happen to know he does not mind.
Okay. Thank you for the permission. So Mr. Horn, we had a hearing in the summer, a very long and challenging hearing involving both Mr. Horn and Mr. Jackson. And one of the issues that became apparent to the Claims Commissioner's office was that Mr. Horn did take a loan that required him to pay back a huge amount of money on top of what he borrowed. So that's a concern to the lawyers. I believe it's a concern to the lawyers who represent the state to make sure that all of our citizens are treated fairly. So we started to talk about having a separate proceeding to investigate this loan amount. But then I felt like maybe that I might be going beyond our authority under this statute. So we decided to not pursue the loan in Mr. Horn's case, the specific details. But I think I did mention it in the written decision that the Claims Commissioner's office issued. So I believe there's general concern in the community that these loans have to be looked at and maybe have to be regulated in a way that the Judiciary Committee feels is appropriate. Like any other loan that citizens take. I mean, they should be fair. And I'm not sure. I get the sense that these loans that are being offered to these gentlemen who are released from incarceration, I get the sense they're not fair. So our office would be in support of working with this committee and other interested parties on what might be an appropriate resolution. Maybe there's something you put in the statute.
Thank you for that. Questions from other members of the committee, questions from other members of the committee. If not, Representative Staffstrom.
Thank you, Mr. Chair. And Mr. Claims Commissioner, sorry not to be there in person, but my co-chair told me he didn't want to get the flu. So here I am. Look, I guess I'm struggling a little bit on the ones that you didn't do a hearing on, sort of similar to the remarks made by Representative Fishbein. And I get there needs to be a process by which claims can be settled out and folks can decide not to have to subject themselves to a full hearing. And certainly just this morning, we had a lengthy discussion on a settlement that the state presented, and the majority of the committee believed that the settlement presented was a better deal for the state than if this had gone to a jury. And so, I get why, certainly in my own practice, I know there's value oftentimes in settling out cases, but it strikes me, and I know we're in uncharted territory here. This is sort of our first time going through this, but this is a lot of money. I mean, we are talking tens of millions of dollars in the aggregate here. And tens of millions in state tax dollars. I think certainly on a going forward basis, I think there has to be some findings on the record in these instances. I mean, no different than sort of sometimes when a stipulation is presented in court. But I think there has to be sort of either a proffer of eligibility or some sort of finding. And I guess would look for your sort of feedback and guidance on that. But it does strike me that there probably should be something on the record that says, look, I'm making an award because this person either was innocent or was released on grounds consistent with innocence, or there was malfeasance. Because to the point, the statute is not designed to compensate every single person who serves time in prison and then is ultimately released from prison. It is directed at sort of those two specific types of claim, and avoiding lawsuits on those particular types of claim. And I guess can you give me some guidance or some insight sort of into the process and sort of how you foresee it going forward?
Thank you, Rep. Stafford. I mean, we all hope you feel better here at the Claims Commissioner's office. Yeah, I mean, these claims are unique. I get it. I can't help but thinking, and there's some litigators here in the room today, that if a judge said to a litigator, I can't allow you to resolve this case informally unless there's a proffer on the defendant's negligence or liability. And you do it too, Rep. Stafford. I don't know if that would cause a problem in getting things resolved, but claims, wrongful incarceration claims are unique. And if the committee believes that has to happen, then we'll certainly do what the committee wants us to do. So going forward, and we have 7 pending wrongful incarceration claims we're trying to get up for a hearing or, move forward quickly. We'd be happy to let the parties know that there has to be a proffer as to eligibility before the Claims Commissioner's office could agree to a settlement. I just think that and I think some parties don't want to go to a hearing. They'd like to resolve it without a hearing for the reasons that our team explained. I mean, these things are really hard.
Yeah, so I guess I'm not suggesting there needs to be a hearing on each and every one, and I don't take issue with, I think one of the claims you went through with the ranking member where you said, hey, I'm going to award above, I'm going to use my authority to deviate upwards, and you let the parties figure out the amount that was fair. I don't have an issue with that in the least bit. I think that's perfectly fine, and it's no different than a judge saying, you guys go out in the hall and figure this out and come back in and let me know what you come up with. I don't have an issue with. But the Claims Commission is a delegation of legislative authority, and the statute says in order to be eligible under this special criteria in this formula, you need to meet certain criteria. And so I think there either needs to be a finding of eligibility or there needs to be an admission by the state of eligibility through the AG's office. And then in terms of the AG's office and the claimant working out a monetary amount to be awarded, that's where the settlement comes in once we know the statute applies. I think it's 2 different questions, and I think one is absolutely appropriate for resolution without a hearing. But I guess, I do think there needs to be a finding that the statute is applicable.
Yeah, that seems like a reasonable suggestion. I can't speak for the state on that. So very happy to be part of any further discussions. I hear you. We hear you loud and clear. We get it.
Because I mean, to the point, I mean, you could have situations where someone says, you know, look, I served 20 years in prison. I was, you know, I'd like compensation for that. But to the point made, I mean, if the reason was ineffective assistance of counsel, that's not a grounds for eligibility under the statute. I mean, maybe it could be, but it's not a ground under the statute. So if that's the reason why someone is before your office and they're pleading ineffective assistance, you know, I think that needs to be sort of dealt with before it gets to kind of the monetary amount, and then the monetary amount can be negotiated.
Yeah, I agree. I don't think the Attorney General's office would agree that that person was even potentially eligible, and they wouldn't settle the case, I don't think, or they wouldn't offer settlement.
Okay.
But I hear you. We hear you. Yeah, so this is an important issue. And again, this was the first year we were testing out this statute. We had 8 claims that were, you know, ready to resolve. And from our perspective, we think that's a good thing that these things are getting resolved, particularly the 5 that were resolved without putting these families through these horrible hearings. As Janae suggested, they're really hard. So, but if we have to do the hearings, that, you know, we'll do what the legislature needs us to do to make sure that there's a fair result, for sure.
Yeah, and I get it. I mean, remember the rationale for the statute, right? I mean, the rationale for the statute is to avoid these being full-blown court hearings, which are even more intensive and more of a drain on both the family and state resources, et cetera. So we're already providing a streamlined process through this statute. And like I said, I just want to make sure that we're not handing out awards to someone who's not deemed eligible under the statute. And I think once that threshold determination is made that someone is eligible under the statute, then absolutely, in terms of the actual amount that's awarded, I have absolutely no problem in that being.
We could probably do that if the parties agree without even changing the statute. That could be something that the Claims Commissioner's office could easily say, is if the parties approach us with a proposed settlement, we can say, well, please give us the your statement on eligibility. It sounds right, but again, I can't speak for the Attorney General's office, who represents the state. But
Sure, understood.
Yeah, we're ready to do whatever everyone needs us to do. We want to do it right.
Thank you. Appreciate your work on this.
Thank you, Representative Stasham. Representative Fishbein for the second time.
Yes, thank you, Mr. Chairman, for the second time. I just, as long as we talk about, you know, working on, you know, perhaps changes, I would suggest that any office that was involved in the underlying would sign off on that. You know, the AG's portion of this is really not so much the underlying, it's the aftermath. So, you know, somebody had suggested the state's attorney's office, you know, I think they should have a part in, you know, signing off on some sort of agreement if that's the case. You know, I just want to have something to review. So I just wanted that mentioned, and I don't know if we need to talk about a legislative fix for this session, but certainly I think we have a duty to the taxpayers. So thank you, Mr. Chairman.
If I could just understand what you're saying there, Representative Fishbein, so we can make note of it.
Sure.
You need someone from the AG's office to sign off on it?
Well, we're talking about the parties, right? So right now, these stipulations have been merely the Attorney General's office, which I don't think in any of these cases were they involved in the underlying conviction, right?
True, yeah.
So you're having somebody arguable, when you say the parties signing off on, you're talking about the AG's office and whoever's representing the incarcerated individual, where the state's attorney's office may be saying, hey, you know, we didn't screw up anything here. And the exoneration is based upon some other thing that doesn't meet the level of the statute. And we object to any aspersions cast upon our office for malfeasance because this person should have been found innocent in the first case, and it's our fault for this person to be incarcerated. I think they do have a place a place at the table to sign off on any such stipulations. So that's my opinion.
Yeah, I think that's fair. I understand.
Thank you, Mr. Chairman.
Thank you, Representative. Are there other questions from members of the committee? Seeing none. Thank you very much, Mr. Commissioner, for your testimony, and thank you all for your work. Next, we will hear from Brian Danforth.
Oh, it worked.
Welcome. The floor is yours.
Thank you very much. I actually haven't tested. Last time I testified before any committee was during the concrete issue way back in 2018, 2019. I did have heavy involvement with that. I think that's in Representative Senator Kissel. I apologize, but his neck of the woods. I actually went before the Supreme Court on that. I'm going to be very brief, though. I'm here on HJ number 54, Edwin Glass. I was the attorney that represented him in his claim with the Claims Commissioner. Mr. Glass spent a lot of time in jail, and his decision was overturned by the appellate court in State v. Glass 214, Conap 132, and that was decided in 2022. I'm sure you all have access to that decision, and it speaks for itself. I just stand here on behalf of Edwin. And this was a dispute. I've heard a lot of testimony, which was very interesting to me about the statute and its intent and what it means. And it seems to be a relatively new issue with regard to some of the changes and what have you. I had to go through it myself. And this was a settled claim based on the potential arguments and potential problems that existed. And as a civil litigator of almost 30 years, that's how we work. And we did our best to resolve this on behalf of Mr. Glass. And I really don't want to add much more to that.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none?
Wait.
Oh, Representative Staffstrom, sorry.
Thank you, Madam Vice Chair. Attorney Danforth, Mr. Glass was one of the cases on here that did not go to full-blown hearing before the Claims Commissioner, correct?
That is correct, Representative.
Okay. What is the grounds for eligibility under the statute on this claim?
That would be under 54-102 UU is what you're referring to, Section 2. I do have the statute in front of me. The Part 1, of course, his conviction was vacated and reversed pursuant to that case I told you. And then we have to go to the second ground. And as a litigator, I've got to go through and meet those standards exactly as you were saying before, along with Representative Fishbein. Subsection A, it wasn't dismissed on the ground of innocence. We can all read that in the case. So I had to go to Section B. And the issue in this case had to do with the DNA evidence that was presented. There was a piece there that had 3 pieces of DNA, but the one that could be identified was just his, and the other 2 weren't tested. And there was an issue of whether or not there was even some sort of gloves in the first place that were ever there in the first place. Even the victim herself had serious doubts as to my client being there at the time. Nonetheless, that one little piece there, how that got there, that would probably be the basis under subsection B, and whether or not we could meet the standard as required by the statute regarding either malfeasance or misconduct. We made that argument. The state, for whatever reason, looked at it and decided to make a settlement. There's always risks involved with any type of litigation. I felt I did the best I could for my client, and the state of Connecticut, for whatever they were faced against, felt that was in the best interest of the state of Connecticut. That's all. That's pretty much it.
Okay. What was sort of the allegation of malfeasance then? I mean, what was the basis for your argument of malfeasance?
The best argument, I suppose, would have to be whether or not there was some issue as to how that got there. It's a very hard standard to meet. I'm not going to lie to you. That's why the initial claim, as you can see, if you probably have it in front of you, was for almost $1 million, and it ultimately settled for 120. It was a very difficult standard to make, but that would be the only argument I could make is questioning how it got there and whether or not it did meet the definition of malfeasance and or serious misconduct.
Okay, so nobody knows how the glove got there, or was there some suggestion that somebody had planted it, so to speak?
I'm not aware of any suggestion at the time, so I'll give you a second.
I apologize. I'm good. Thank you.
No.
Thank you. Further questions from the committee? Further questions? Seeing none, thank you very much for joining us this afternoon.
Mr. Chairman, I had my
Oh, Representative Fishbein.
Yeah, I just wanted to follow up of that line of questioning, if I may. Sir, were you the defense counsel at trial?
I was not.
Okay. Have you had an opportunity to review the transcript, the trial transcripts?
Myself and a couple of other people, yes.
Okay.
I did my due diligence and had everything thoroughly looked into for this case.
Sure. And is it fair to say that defense counsel in this case did not cross-examine with regard to how the DNA got on the implement?
I don't recollect off the top of my head. I looked at that a long time ago. But I did have I did have a couple of people look into it thoroughly because I'm not a criminal lawyer. I am generally a civil lawyer, so I've got to rely on people in that area of expertise and ask for their opinions regarding the actual conduct of the trial itself.
Sure. So when you say the malfeasance could have been how the DNA got on the implement, it would be fair to say that that would be an area that a competent defense counsel would inquire of when their client is facing many years in prison.
Perhaps, like I said, I did have somebody go through that to try and explain it to me as far as it went. There are, I know, experts out there that exist for the purposes of preparing defense counsel for cases regarding DNA and how it gets there and transfer and what have you. Actually, the person I talked to used to work for the state and went through that for a long time with me. And there are certain strategies that defense counsel employ that are good on behalf of their client. Whether or not that should have been utilized or not, again, I would defer to another expert, but there could be a reason why. For example, there are cases in my civil practice where one would say, why didn't you pursue this avenue? And based on my experience or the type of evidence before me or the certain elements of whatever civil issues before me, it might not be beneficial in my client's best interest to go that route.
Yeah, and I'm just looking at the statute. 54102 UU deals with malfeasance by a state or governmental actor. And I'm just trying to figure out what you're talking about malfeasance with regard to. Is there some accusation that DNA was planted in this case by a state actor?
No, I've not seen any allegation regarding that, but there is, it got there under questionable circumstances. Does that meet the statute? I didn't find a lot of case law in statute 154, 54-102, sorry, UU. So if for me, when I go through and I look at any civil case, I try to find what different precedents are or what different facts have been applied to that type of statute. Doesn't matter whether it's an auto accident or a breach of contract claim or what have you. So setting that standard is usually done through case law and common law, and I didn't find much of anything with this. At best, my case would probably be a test of what the term malfeasance and or serious misconduct could be under the statute. And whether or not I'm right or wrong would be up to a trial judge, a jury, and or an appellate court if it even got that far.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you very much for your testimony. Let me just check one more time. comment or question from other members of the committee? Comment or question? Seeing none. Thank you very much for joining us this afternoon.
Thank you all for your service.
Okay. All right. Those are the folks that we had signed up to testify. Can you give us 1 second? Okay, we're gonna, yes. We're gonna have a slight pause here. Okay, and we're going to have the Attorney General's office speak to the nature of the process, not necessarily specifics of individual cases before us. You may proceed.
Thank you, Senator Winfield. I'm back this morning. Again, those of you who don't know me, I'm Eileen Meskel, Deputy Attorney General. With me is Terry O'Neill, our Section Chief for Public Safety. And yes, this is a little bit different process than what we were here earlier on in terms of what we're used to under a different settlement process. And with the wrongful incarceration claims, while I don't have all of the details, because again, this is sort of a new process for how this unfolds in terms of all five. I think there were five in which we did an agreement with the other party. What I can talk to you about, at least in general terms, is that we do take a hard look at obviously eligibility under the statute, previous hearings that we've already had at the Claims Commissioner in terms of eligibility, what our risks are and what we can achieve, if we can achieve obviously a good result prior to going to a hearing. But in at least two of the claims, and we're, by the way, I also want to say that because I don't have all of the information on all of those, but we are happy to submit something. I know you're scheduled to vote today, but if you want us to, we're happy to either come back or submit some documentation to outline why we agreed to awards in those five cases. So at least two of them that are on there, and Carmen is one of them. I remember some of the facts there, had also legal malpractice claims that were also pending, a separate claim, and that's certainly a consideration when we look at a stipulation. And, the challenge for us is we aren't involved in any of these cases. These are the state's attorney's office, the police departments, and a lot of these cases go back a very long time. But we do work, we do meet with them. We try to understand. It's very, to recreate and go back. And so to the extent I can give you an assurance that we take a hard look at before we agree to any stipulation about what may or may not happen in terms of eligibility, that is something we clearly do. But like all cases before us, and that process, we're happy to have a discussion about what that process should be in these cases. We settle cases, that we have concerns about, what would happen if we went to a hearing. And not all of those do we want to obviously concede. And that's true for every case, whether it's these cases, Claims Commissioner, Superior Court, federal court, whatever. And so, you know, I'm happy to, and we're happy to talk about that process, like the Claims Commissioner already said, and what you would like to see going forward.
Thank you. Comment, question? Senator Kissel?
Yeah, that is my name. Thank you, Mr. Chair. No, thank you, Attorney Meskel. Yeah, you guys have the reputation of not giving up easily on anything, being very dogged in your defense of the state. And so you know, the reputation, I feel very much assured. On the other hand, I think the points raised by Representative Fishbein and Representative Staffstrom are easily understood and on point. And I think the commissioner looked at it like a proffer of evidence. I would look at it like maybe as a stipulation. But this is after you're doing your rigorous investigation as to, you know, whether it meets the criteria. And then I think for the legislature's comfort level, just like we are reviewing something in a court-like setting, we just need something on the record that we can rely upon, that all the i's are dotted, all the t's are crossed. But I don't have any doubts that underlying all of this was a rigorous analysis by your folks. And they weren't giving up any territory easily at all. And so I think that we can get from here to there. I leave it to my colleagues in the leadership and the rest of the committee as to whether we want to move today and just wait for that to follow us, because these still have to be acted upon by the chambers, or whether they have to have a comfort level where perhaps the ones that were settled have to trail a little bit, or how it all shakes out. But there's some things in this building that seem intractable, but I appreciate your willingness to work with us, at least from myself. And I think this is an easily solved issue. That's all I want to say. Thank you. And I appreciate your cooperation.
Thank you.
Thank you, Senator Kissel. Representative Staffstrom.
Thank you, Mr. Chair. Attorney Meskel, I guess sort of same question that I asked you this morning on the settlement, right? With respect to these 5, I guess, stipulations that didn't go to hearing, is it the Attorney General's office position that these are the best deals for the state of Connecticut? And by that, I mean that there is at least a good probability that these individuals would be eligible under the statute for wrongful incarceration award, and that if these were to go to full hearings, that the state would risk an even higher amount being awarded against it.
Yes, I'm happy to assure everyone here that we feel confident and doing our due diligence and I say recommending in stipulating to these awards.
Okay, thank you.
Thank you. Representative O'Day, I'm sorry I skipped you. So you can go now, followed by Representative Fishbein.
Thank you very much, Mr. Chair. Sorry, my hand might have been slow. Just real quick, if I may, it just seems to me, not having delved into this area much, anywhere near what you all have, that the state's attorney's office might be a better place to be a gatekeeper, at least an initial eligibility review. Would you agree with that?
I would agree.
All right. Thank you very much, Mr. Chair. Thank you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. You know, I've never found myself really attacking the AG's office so much as today. So I really have to apologize, because I hold both of you in very high regard. And I too have known Terry for many, many years, probably not as long as O'Day. But anyway, you know, the glass case that we were talking about with with the attorney, what made him eligible?
I don't remember. I obviously at some point would review all of these as part of administration. That particular one does not ring any bells with me. Do you have any, Terry? Oh, so he received a judgment of acquittal, which I think we believe is a pretty strong indicator that he's eligible under the statute.
Okay, um. So the AG's office has interpreted an acquittal as being grounds consistent with evidence, because that's the only portion of the statute that would fit.
Yeah, that consistent with innocence, because a judgment of acquittal certainly is different than even charges being dismissed.
Okay. But you heard the lawyer, like, it didn't seem like he was really overly confident on that aspect of the case. So why does the AG's office take that position? Is there something in the legislative history that ascertains that?
I'm sorry, are you asking about whether judgment of acquittal is in the legislative history? Or are you?
Yeah,
Okay, I don't know if it's in the legislative history. I do, one thing I would say is, that number obviously is the proposed stipulation on that was fairly small compared to what the ask was. But I think when we see judgment of acquittal, and this is and we talk to, and we look at the evidence and talk to the state's attorney's office to the extent there's, well, not only that they're still there, the ones who worked on it, but what their view of things are. We make a judgment call, but it's not just that, because we're obviously doing these cases all the time before the claims commissioner. So, and in this case, the Commissioner Shea. So we get a sense, or we try to get a sense of, where our risks are, just like in any other case. And I think that goes to, if the other side, which is what he indicated earlier, believed that there was a risk, I think that shows the value of what they agreed to in terms of the number. And we do the same analysis in terms of what we think is going to happen if we went to a full-blown hearing.
yeah, but I'm trying to put the pieces together. So the AG's office takes a position that a judgment of acquittal is, you're entitled to the max under the statute, right? So that's what I'm hearing on one hand. What the lawyer thought, I mean, maybe this lawyer has committed malpractice because he didn't take the $936,000 that the calculation would call for. So I'm trying to separate the two, right? So I don't know. This is not working. So anyway, all right, well, I got a lot to think about. So thank you, Mr. Chairman.
Thank you, Representative. Comment, question from members of the committee, comment, question from members of the committee. If not, thank you for answering those questions for us. We deeply appreciate
Thank
it.
you.
Okay, so that would bring us to the end of the public portion. So we are going to go into our committee hearing, and we are going to recess, but let me tell you what's going to happen. There's going to be a meeting of the Republicans in 2600, a meeting of the Democrats in 2D. We'll stand in recess until those meetings are over, and then we'll come back and hopefully have some votes, and folks can go spend the rest of the evening with their loved ones. Thank you. All right, good afternoon. We are back.
Yeah.
And Mr. LCO, you tell me when I do this wrong. All right. So remarks, seeing none, thank you very much. We are under Roman numeral 3, which is the review of wrongful incarceration awards ordered by the Claims Commissioner. And I would like a motion for items number 2, which is Senate Joint number 41, item number 3, which is Senate Joint number 42, and item number 5, which is House Joint number 51.
So moved.
Second.
Moved by Senator Kissel, seconded by Representative Flexer. And I think Senator Flexer, moving a little fast, sorry. We both were representatives in the past. We don't have a problem with representatives. And I would I would like to see if we can get a voice vote on that. All in,
No.
I knew it was going to happen.
Yeah, Senator, you'll need a roll call vote on
Okay.
that.
All right. So I would love to have a roll call on that. And Madam Administrator, if you can, please call a roll.
Roll call vote on Senate Joint Resolutions 41, 42, and 1. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Gadkar Wilcox, Pazino,
Yes.
Kissel, Fishbein,
Representative Fishbein votes yes.
Blumenthal, Brown, Cabrera,
Yes.
Callahan,
Yes.
Chickarella, DiCaprio, Delaney.
DiCaprio votes yes.
Thank you. Delaney,
Delaney, yes.
Dillon,
Dylan, yes.
Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott,
Elliot, yes.
Gaston, Gilchrist, Godfrey, Howard,
Howard, yes.
thank you. Jacobson, Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser,
I will note that Representative Lesser will be recusing himself on item number 3.
Mar, Miller,
Madam Administrator, for clarification purposes, is item number 2, 3, and 5, or just 2 and 3?
I believe this is 2, 3, and 5.
Okay, thank you, Madam Administrator. Then yes.
O'Day,
Yes.
Osborne,
Yes.
Havelock Tomato,
Havelock Tomato votes yes.
Quinn,
Yes.
Rahman, Roberts, Rutigliano, Sampson, Sims, Beach,
Yes.
Walker, Wilson,
Yes.
Blumenthal. You're muted.
Madam Administrator, I recuse on item number 3 and I vote yes on the other 2. Thank you.
Okay, thank you very much, Madam Administrator, and we'll leave a little bit of time at the end so that folks can make sure that they've gotten their votes in. We'll tell you what that time is when we get there. Next, I'd like a motion on item number 1, Senate Joint number 40, item number 4, Senate Joint number 43, item number 6, House Joint number 52, number 7, House Joint number 53, and number 8, House Joint number 54. And the motion is, the motion to remand these resolutions to the Office of the Claims Commissioner for determination of eligibility to receive a compensation award pursuant to subsection A of section 54-102 UU.
So moved.
Second.
Moved by Senator Kissel, seconded by Senator Flexer. I want to make sure I didn't say representative this time. Discussion. Senator Kissel.
Thank you very much. It's the intention not to necessarily reject these matters, but it's remanding them to get further facts so that we can feel very confident that it meets the criteria established in the statute and that it can be acted upon accordingly in the full chambers of the House and the Senate. Thank you, Mr. Chair.
Thank you for the question conversation. Seeing none, Madam Administrator, please call the roll.
Roll call vote. Winfield,
Winfield in affirmative.
Staffstrom,
Batchum, yes.
Flexer, Gadkar Wilcox, Pazino,
Yes.
Kissel, Fishbein,
Representative Fishbein votes yes.
Blumenthal,
Blumenthal votes yes.
Brown, Cabrera,
Yes.
Callahan,
Yes.
Chicarella, DiCaprio,
Caprio, yes.
Delaney,
Representative Delaney votes yes.
Dillon,
votes yes.
Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott,
Elliott, yes.
Gaston, Gilchrist, Godfrey, Howard,
Howard, yes.
Jacobson, Johnson,
Johnson, yes.
Khan, Lamarck Muir,
Yes.
Lesser,
Lesser, yes.
Marr, Miller,
Miller, yes.
O'Day, Osborne,
Yes.
Havelock D'Amato, Quinn,
Yes.
Rahman, Roberts, Retigliano, Sampson, Sims, Veach,
Yes.
Walker, Wilson.
Yes.
Thank you, Madam Administrator. Roman numeral number 4, which is a review of the recommended award ordered by the Claims Commissioner. Number 9, which is a resolution authorizing the Claims Commissioner's recommended payment of $50,000 to the claimant. Heather Robillard asked for a motion to for that resolution to be raised.
No move.
Moved by Senator Kissel,
Second,
seconded by Representative. I'm going to give it to Fishbein this time. Is there discussion? Is there discussion? Seeing none, Madam Administrator, please call a roll.
Roll call vote on.
Mr. Chairperson,
Sorry. Yes,
on these, the rest of the agenda, you don't need to do roll call votes. So these
you
could
are
be,
correct. You are correct. Let's see if we can do this by voice vote.
aye,
All in favor? Say
aye,
Bye.
all opposed, nay? Abstentions? And the ayes have it, it passes, right? All right, and then we have Roman numeral number 5, which is 34 concepts to be raised by the committee. Like, okay, they were raised as a group, and second by Senator Kissel, seconded by Senator Flexer. And we could do that by voice vote as well. All in favor, signify by saying aye.
Aye.
Those opposed, nay. Abstentions, great. And that puts us down at Roman numeral number 6, which is a proposed bill to be referred. The referral is to the Finance Committee as proposed House Bill number 6172, an act reducing the filing fee for annual reports filed by certain business entities with the the motion was Senator Kessel, the second was Senator Flexer. All in favor?
Aye.
Opposed, nay. Abstentions? Okay. All right. And when is our next meeting? The 24th, that's correct. All right, so we will stand in recess until we'll stand in recess until 4 o'clock.
Madam Minister, I'm not first in line.
Okay. Yeah, you too. Senator Lesser,
Yes.
on set for the wrongful incarceration awards. We did 2, 3, and 5. How would you like to vote?
Were
wait,
they all
Lester.
together or?
So what
Yeah,
we
I would like
did-
to recuse myself on item number 3.
I was gonna say, we have you as recusing on 3. So on 2 and 5, how would you like to vote?
In the affirmative.
Okay, right, you're all set for that. And then for the others, the other 5 awards, how would you like to, oh, I have you as a yes. And then you're all set for the voice vote. So
Yes.
you're all set.
Okay, great. Thank you.
Thank you.
Okay.
Representative Delaney?
Yes, Madam Administrator, am I recorded as having missed any votes?
Nope, you're all set.
Roger that. Thank you for your hard work. Happy Valentine's Day, and I hope you have a great weekend.
Thanks, enjoy.
Yes, ma'am.
Representative Blumenthal?
Thank you Madam Administrator. Apologies for my confusion earlier. Did you register my abstention from item number 3 and
Yes.
my yes votes for the other 2? And do I have any other outstanding votes?
No, you're all set. We got everything.
Thank you very much. Have a great weekend.
Senator Gaston?
Hello, Madam Administrator. Thank you so much. Just wanted to make sure that my votes got recorded.
Absolutely. For the first section, for the 8 awards, we separated 3. How would you like to vote on those 3? Were there items 2, 3, and 5?
In the affirmative.
Okay, and then for the remaining items, how would you like to vote on those?
In the affirmative.
Okay, then the rest were voice votes, so you're all set.
Yes. Thank you so much.
Thank you.
Have a
Take
great
care.
weekend.
You too.
Take care. You too.
Representative DiCaprio?
All right, just checking in to see if I missed anything.
You look good. You're all set.
All right, thank you.
Thanks.
Have a nice weekend.
How are you? Did you go?
Gadkar Wilcox. If you're there and available, I can take your vote. And also Representative Pavlock D'Amato, if you're there as well, I can take your vote whenever you're ready.
Gonna have to wait a minute. Because I'm driving.
Hi, Representative Jacobson.
Hey, I think I was on the wrong meeting. I was like, why is this taking so long? And then I was like, oh, I clicked the 10 o'clock.
It's because we have a million just for today. Yeah. All right. So for the first set of those awards, we separated them out into two different groups. So for items, for the first group was hang on. For the first group, here they are. We did items 2, 3, and 5. How would you like to vote?
Consistent with the votes of the chairs, please.
Okie doke. And then for the other 5 that we grouped together, how would you like to vote?
Consistent with the votes of the chair, please.
All right, you're all set, and everything else was voice vote.
Understanding was the former was a no and the latter were all yes, correct?
The first was everything was a yes.
Oh, everything's a yes. Okay. And
Yep.
everything. Then I'd like to vote consistent with the will of the chair, please.
All right, you're all set.
Thanks kindly.
Have a good weekend.
Bye-bye.
Hey, Senator.
Hi, do you need, did I?
Yes, I do need your vote real quick. So for the 8 awards, we separated them out into a group of 3 and then 5. How would you like to vote on the first 3? Can you hear me? Oh, you're muted. Hang on.
Which were the first 3?
So the first 3 we put together were resolutions 41, 42, and 51. Those ones had hearings. So we're moving those, and the other 5 we're remanding back to the claims commissioner. So how would you like to vote on the group of 3?
Yes.
And then for the other 5?
For the remanding? Yes.
Yeah.
Yes.
And then everything else was a voice vote. So you're all set.
Great. Thank you so much.
Have a good weekend.
You too.
Hi, Representative.
How you doing? I feel like I was on a meeting. Did I miss a vote?
You did, but the votes were open, so you haven't missed anything.
All right, cool.
All right, so for the first section for the wrongful incarceration awards, we grouped them separately. There's a group of 3 and a group of 5. For the group of 3 that are moving forward, how would you like to vote?
So it's a group of 3 and a group of 5.
So yeah, the group of 3 had hearings at the claims commissioners, and the other 5 did not. So the 3 were
Yeah, I'm good with the group of 3.
okay. So then the group of 5 were remanding those back to the claims commissioner. So how would you like to vote for those?
Yes.
Okay, and then the other things were voice votes. So you're all set.
Yeah. Thank you so much.
You got to have a good weekend.
All right. Bye-bye.
You should be good now. Hi. Maybe. Give her a second.
Hey, Representative, how are you?
Hey, how are you?
Can you hear me okay?
Yep, I got
Okay,
you.
perfect.
Okay, go
All right,
ahead.
let me take this real quick. So we split the 8 awards. I'm not sure if you, but so the incarceration award, we split it into a group of 3 and a group of 5. 3, we grouped because they had a hearing, and the other 5 we're going to remand back to the plaintiff's commissioner.
Okay.
How would you like to vote on the first 3?
Yes,
Group of 3, okay. And then on the group of 5.
3. I mean, yes.
Not there. Everything else is voice vote, so you're all set.
Huh? Everything else,
is voice
that's
vote. Yeah,
it?
you're all set.
Okay, thank you. Bye-bye.
Hi. Hi, how are you?
Good.
All right, so I just need you for one vote, which is the group of 5. I have you for the group of 3. How would you like to vote?
D'Amato votes yes.
All right, you're all set. Thank you. Have a good weekend.
Hi, Kirsten. I'm here when you're ready.
Hi, how are you?
Good, how are you?
Good. So for the first section of the agenda, we split the awards into 2 groups. One group is moving forward as those 3 had a hearing. The other 5 are going to be remanded back to the commissioner's office. So for the 3, which are items 2, 3, and 5, how would you like to vote?
Yes.
And then for the other 5?
So those are, you said the other 5 are going back to the commissioner's office? So the vote is to send them back?
Yes.
Yes, then yes.
And then everything else we have in the agenda was a voice vote, so you're all set.
Perfect. Thank you.
Have a good weekend.
Yep, you too.
Hey there, how are you?
How are you?
Good. Okay, for We split the awards into two groups. So this group of 3 is moving forward. How would you like to vote?
Yes.
And then the other 5, this group of 5 is going to be remanded back to the claims commissioner. So how would you like to vote?
Yes.
All right, everything else is voice vote, so you're all set.
All right. Have a great long weekend.
You too.